press the button so that this is now being live streamed on YouTube. Today is July 14th of the year 2022. My name is Brad Gardner. I'm presiding judge over the first appearance hearing that's going to be held here today. So what I need everyone to understand is that we're not here to have a trial of your case or to take a plea in your case. We're here for me to tell you what you've been charged with or the charges that are pending against you, to set new court dates and to find out if you want to have a lawyer appointed. Those are the only three things that we're dealing with here today. During this and all other proceedings, you're going to have the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you. You have the right to compel the attendance of witnesses to testify on your behalf. You have the right to testify on your own behalf or offer evidence in your own defense. And you have the right to have an attorney represent you. And if you cannot afford an attorney, one can be appointed to represent you. All of the bonds that are issued today are going to be by cash, commercial, or property. Cash bond, you can pay the entire amount of the bond in cash. That money will be returned to you by the sheriff's department once your case is resolved. You have the right to go through a bail's bondsman, and that's the commercial part, where you pay a fee to that bondsman for them to set your bond, or not set your bond, but pay your bond. And that amount is generally about 10 to 12% of the bond amount. Finally, you have a right to have a property bond. If you have property and the property has a value or net equity that is more than 3 times the bond amount, you can put that property up as collateral for the bond. Sheriff's Department will place a lien on that property, and when your case is resolved, they'll take the lien off. There are going to be, for certain people, there are going to be conditions placed on their bond to not go around a certain person or a certain place. And if you violate that condition of the bond, you will be charged with the felony of aggravated stalking. And that will result in your being placed in jail without bond until your trial is held. So it's very important to remember that. Lastly, everybody has the right to have a preliminary hearing. And the purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at that stage is very low. A judge only has to determine that the charge, as it moves forward, that there's a possibility that you committed the offense. Not that you did, but just a possibility. You also have the ability to waive your right to a preliminary hearing. If you're unsure about whether you want to waive your right to a preliminary hearing, you should speak to a lawyer first before making that determination. If you postpone your preliminary hearing, it's going to be automatically waived, and you'll receive notice at the address that you give to the sheriff's department of your next court date. Lastly, could everyone please raise their right hand for me? Do you swear affirm that any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes. Yes, sir.
Okay. Okay. Let's begin on the ladies' side.
Good morning. Morning, Judge.
Good morning. Are you Miss Bentley?
Yes.
Miss Bentley, you've been charged with one count of a child abandonment. Bond is set by schedule, which means it's automatically set at $1,500. This is a misdemeanor offense, so your preliminary hearing date is going to be set for July 26th at 8:30 in the morning. That hearing will most likely be by Zoom. And as I said before, if you bond out, that hearing date is going to get waived and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? I'm sorry, man.
What was that, sir? I'm sorry.
Do you want me to see if you qualify for the appointment of a lawyer?
Yes. Yes, please.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, do you have any questions of me?
Yes. Well, I actually did not purposely miss my court date. I was actually attacked that night by my mother and okay. Well, yes, I had a change of address and the court date was sent to the wrong address. So I did not receive the hearing. I didn't know. I was unaware of it. And they did not send it to my correct address. So I did not know about it. So that was not purposefully.
Okay. So, ma'am, with this particular charge, are you the custodial parent of
Yes,
the child?
I am.
And is the alleged father, Mr. Is it Deaton?
Yes, Deton Johann Schroeder.
Yes.
Yes.
Okay. Well, so with this particular charge, if you're the custodial parent of the child, and if there's any evidence that you have taken custody of the child within a 30-day period, this charge should be dismissed. And my understanding was that for these hearings that there was an effort to make certain that there was personal service of all parties, so that there's not a situation where there's an allegation that a person didn't know that the was going to be held.
Yes, and I'm sorry, he's refusing to give my daughter back to me. I'm sorry. Yeah. Yes, and I'm sorry, he's refusing to give my daughter back to me. I'm sorry. Yeah. Okay.
What I would say to you, ma'am, was child born within a marriage or outside of a marriage?
Outside.
Was there any steps made to legitimate the child?
Yes.
So the father has been legitimated and named as father.
Yes. Now we has.
Okay.
Recently.
So you should speak to your lawyer about this, because from a standpoint of dealing with these allegations, if a parent is shown to have, for instance, taking the child for one day, child is at that person's home for one day, that's enough to satisfy the statute where the child is not being abandoned by the other parent. So you really, I would encourage you to speak to your lawyer and really take steps to protect yourself. Okay.
Yes, I have to. Like, yeah.
Okay. All right, ma'am. You're free to go back.
Okay, thank you.